Home Affairs is inviting members of the public and interested parties to submit written comments on the marriage bill. The draft legislation intends to rationalise South Africa's marriage laws. Yesterday, Minister Aaron Motsoaledi held a ministerial consultative dialogue at the Constitutional Hill, where civil society groups and ordinary South Africans gathered to share their views on the proposed legislation. The closing date for written comments is next week, Thursday. But to get a legal analysis on this topic, we are now joined by Nthabiseng Dubazana, a legal expert with Dubazana Attorneys. Nthabiseng, thank you so much for your time and for joining us this evening. What was your initial reaction to the legislative bill?
It was actually a sigh of relief. It is quite difficult to deal with the various aspects of marriage in our country and to try and consolidate that when things get bad, when there's a divorce, when there's a death, we have to see which kind of marriage is applicable to the couple or to the person that comes to us, and then it's such a nightmare. As it is, we recently got a court order in the High Court, if I'm not mistaken, that still needs to be confirmed, wherein marriages that are conducted in terms of Islamic law, they are now finally getting recognized, and for the purposes more than anything else, for the death of any spouse, then the surviving spouse, especially the woman, can now inherit from the deceased estate. So it is going to be a much needed relief. In terms of if it does get passed and is accepted by everybody who's going to be voting for it, and we hope that they do, because it will make our lives a little bit more easier.
Some have argued that perhaps the bill is not so all-inclusive. Does it reflect changing social and economic conditions? Because it seems not to really address the issues of cohabitation.
Yes, or it hasn't touched anything pertaining to cohabitation, to be quite honest. It is just dealing with the issues of customary marriages, religious marriages, and civil unions, as well as marriages under the Marriages Act. They're basically being consolidated under one umbrella, so it's not like you have to deal with different variants of marriage when there is just marriage under the same umbrella. Our law hasn't developed enough as yet to include cohabitation. However, it does state in the Act itself, in the bill rather itself, that if there is a marriage, albeit it doesn't fall within the ambit of what the bill is proposing, then there can be a dissolution of that partnership or joint venture, for lack of a better term, and the judge or the presiding officer can divide the estate in the way that they feel is just in that situation. So that could be a loophole that you could use in terms of litigation that deals with cohabitation. But as of where we stand right now, people who are cohabiting still are not going to be recognized as spouses for the purposes of anything pertaining to marriage, even in terms of intestate succession, unless, of course, as a child that is born out of that cohabitation, then they can inherit from the deceased estate in terms of the Intestate Succession Act.
Speaking of children, one highlight that came out of the bill in terms of what could be passed is parents consenting to children under the age of 18 to getting married, as currently is in the country. What's your take on children under the age of 18? Because we do know that many of them have not reached the age of maturity in order for them to make consent when it comes to marriage. But now parents and families are also prohibited from allowing these young children from getting married.
Yes, that's very true. And under the bill, parents that do allow this to happen are facing anything between 5 years imprisonment and a fine should they allow such a marriage to proceed as a result. So what is going to happen is that any person under the age of 18 is not permitted to marry under the new bill. And if you are going to marry, you have to not only be over the age of 18 and above, I beg your pardon, but you have to have capacity of understanding. So if I may make a use of criminal law in this aspect, We have what we call criminal capacity, which is criminal understanding of what your actions are. So this capacity that is being referred to here in the bill is understanding what it means entering into this contract of marriage, the implications of it, and what you should do going forward. So this person knows what they're doing and how it's going to affect them and the partner and any other person that's going to be affected by their actions. And if the peace officer or the person who's going to conduct the marriage can confirm that these two parties have the capacity to understand what it is that they're doing, and they produced their ID to confirm who they are and that they're over the age of 18, then they can proceed with officiating the marriage.
And I think the spirit of the bill really is to protect the rights of those who generally wouldn't have been protected. We see when it comes to polygamy that now both parties who are involved in the marriage need to agree in introducing a third party, as opposed to a husband coming with a new wife and the first wife not having consented to polygamy.
That's correct. So the law primogeniture, even though it was repealed in 2004 when we dealt with the Beg case back then, it wasn't completely outrightly removed in the sense of polygamous marriages like you just stated. The only thing was that when it comes to litigation, that could be raised as a defense that I, as the first wife, did not give consent for a second wife or third, whatever wife, to become part and parcel of this marriage contract. So what has also been added in the bill is that upon having received consent from the wife or wives that are already part of a marriage, there has to be a court application. And in this court application, you have to now put in what we call the guidelines, for lack of a better term, on how the estate is going to be dealt with. So the applicant will be the husband, and the respondents will be all the wives, if there's more than 2 or 3, so that contract can then be made to be applied to each household and the dynamics of that particular household. And if the presiding officer is happy with how the contract is going to protect the parties involved, particularly the wives and the minors involved there, then that contract will be made an order of court, and it will be given to all the parties involved so that they can have a copy of them, and it will be registered as a marriage in that sense.
So in the absence of this application, then the polygamous marriage would be considered null and void?
Yes, it will be considered null and void, because remember, with the new bill, what is also now proposed is that after your marriage has been officiated, you have 12 months to register it. So even if you were to do all the celebrations in terms of custom and all of those things, this application has to happen. And then that can be then deemed that this marriage is now recognized in terms of the law, and using that contract, it can now be registered at Home Affairs like any other marriage in terms of the bill.
Nthabiseng, what would you say to traditionalists who would argue the erosion of African traditions, especially those that would allow for underage marriages and that would allow for the non-consent of a wife when it comes to a polygamous marriage?
So our law does accommodate for customary law to be evolved and developed. It doesn't erode it. So it doesn't happen outside of consultations with traditional persons in our law, the kings and queens, everybody who's the custodians of our customary law. These kinds of things are discussed with them before it is put in as a proposed bill in any manner or form. So having said that, yes, it may be an erosion in the eyes of people who see it in that manner. However, we also have to look at the consequences of having children, and it's always the little girls who would get married off more than it was the little men or little boys who would get married off. So we need to look at what the consequences of that was in the past. The main reason when it came to the Beg case, for example, when it eradicated the law of primogeniture, it was saying that as long as you are a woman, you do not have a right to inherit from your husband's estate. as soon as your husband has died and you're married in terms of customary law, then the brothers of your husband can kick you out of the home along with your children. So now this is made to protect the rights of the children so they can have at least an attempt at a brighter future. I think that is what we need to push as a forefront instead of saying that our tradition is now being thrown away.
Most certainly. Nthabiseng, thank you so much for your inputs this evening. Truly is appreciated. That's Nthabiseng Dubazana, a legal expert with Dubazana Attorneys.